The lawsuits in North Carolina continue as Judge Bledsoe rules in the motions to dismiss or stay.
The ACC lawsuits are always in the news, so we're back on the big mountain to take a deeper look.
How you doing again? I am JY. This is my good friend Steve. If you're new to the mountain, we welcome you, but I have a funny feeling a lot of the viewers have seen us before on these FSU ACC lawsuits, so we welcome you back. On Thursday, April 4th, the Honorable Judge Bledsoe issued an order and an opinion out of the Superior Court in Mecklenburg, North Carolina, on the FSU motion to dismiss or stay the ACC action in North Carolina. Massive headlines on Thursday. There was a lot going on Thursday. I know we were texting, like, we got this and we got that.
Yep.
But anyway, we're focused on this. In this episode, there was a 76-page order and opinion that he put forth on this. Has a lot of detail, goes through a lot of case law, references a lot of case law as judges would do, so you can understand why he's coming up with his conclusions and his opinion. I'm going to try to stay focused on the main points that we've been highlighting here for several episodes specific to the Mecklenburg County case. The deeper dive here, Steve, is going to be on those kind of 3 or 4 main issues that we've been talking about. As a reminder, we talked about standing, both in terms of the materiality and in terms of the ratification part to that. We talked about sovereign immunity, and we talked about ripeness. The last episode we did on the hearing, we kind of gave our opinion as to where we thought there could be some smoke in some of these items that we just thought were almost non-starters. And I got to say, Steve, here, I think we did pretty good on how we read this, what we kind of thought was gonna happen. We were a little bit unsure on the full motion to dismiss or stay, specific to materiality. And my main focus there was materiality. He actually spun it around and focus more on the ratification piece. Yeah. And you were correct on that early on. I know you started to, as we got into the hearing and some of the Q&As with the judge, you were maybe kind of questioning that, but you were spot on that ratification from the very beginning, Steve.
Yeah, it seemed like it was something that was easily remedied, and I thought that's where they would go. And then FSU made their arguments, and their arguments that were kind of maybe slightly compelling.
Yeah.
But what really made me question it was the questions that the judge asked during the hearing.
Yep.
And now we have his ruling. So.
For sure. You and I both were pretty clear on the ripeness piece, that wasn't going to be an issue. It was not for this judge at all. We'll get into that. And also the sovereign immunity piece that was really one of the things early on, especially from the FSU commentators' side, that they thought was going to be a big issue. You know, we did a poll on this, not scientific at all, but it was, sovereign immunity was actually the lowest one that people clicked on in terms of where they thought the most smoke would have been, which really surprised me, and we're going to get into that and why he got over that whole sovereign immunity piece here as well. So, he denied the motion to dismiss with one exception. We're going to get into those details kind of later on. Yep. And he totally denied the motion to stay. The motion to stay is out. There was one exception to the motion to dismiss. The 3 main sections here that we're going to discuss are that the ACC filed a dispute before a controversy arose. Again, that whole ripeness argument. Yep. The ACC failed to obtain a vote prior to the initial action. Again, that was the standing piece. Mm-hmm. And then the third piece, that FSU cannot be sued in North Carolina because it has not waived sovereign immunity except within the boundaries of the state of Florida. So let's first talk about the actual controversy, the ripeness issue. The court found FSU's argument that litigation was still speculative and not unavoidable because the FSU board had not yet met or vote for the initial action by the ACC to be without merit. So that whole rush to the courthouse case that you heard over and over and over again, the judge says that was without merit. He stated the wording in the grant of rights states that the ACC, direct from the grant of rights, was entitled to enforce the protection of the grant of rights when a breach was imminent. Moreover, the ESPN agreements state that the ACC is obligated to, again, quote, take all efforts to protect the rights provided to ESPN. while this agreement did not require action by the ACC, it did give the right to initiate action at the discretion of the ACC. And that piece we actually didn't talk about when we talked about the hearing here, but we did. I think our last episode was on kind of a response that the ACC did to the motion that FSU, a response by FSU to the motion the ACC did in the Florida case in Leon County, and it gets right at that. And I got a little pushback from commentators when I read the grant of rights and what they say. Well, guess what? It wasn't just JY reading it that way. At least the judge in North Carolina reads it that way too. That doesn't mean the Florida judge will read it that way. But, this is exactly the way I read it. It's exactly the way Judge Bledsoe read it. So he then, this gets into the definition of this commercially reasonable efforts. Again, another thing, this was, in that response by FSU in Florida, another thing that they had just brought up in terms of, this is new, we got to bring this up, this is an issue. Well, he talks about this here in the North Carolina case. So this came out of after the hearing in which FSU has used a response to the ACC motion to dismiss in Florida. He's referencing that in Florida. This judge, at least, has stated that issue raised by FSU holds no water in this case, as it gave the ACC the right to initiate this action while agreeing it did not require this action. It's going to be interesting, as I said, to see if the Florida judge has the same type of opinion here. He then lays out the timeline going all the way back to February of 2023, so over a year ago, that showed a breach was imminent. So he completely agreed, basically, with the ACC's point on this whole ripeness piece. Yeah. Anything there, Steve? And then I'm going to get into standing.
Well, like you said, the whole time we thought the ripeness issue, that was going to be one of the easiest decisions.
Yeah.
It was very obvious that this was imminent. The Florida State Board of Trustees telegraphed this. It just, to me, that was the easiest, and it makes sense that he kind of tackled that issue first and knocked it out of the way.
Well, and that last sentence about the timeline, I made it very short, but in his 76 pages, there's several pages as he lays out the timeline of what occurred. We've gone over that before. I'm not going to waste time here. Let's get into standing, the one that we had maybe the most question about. We weren't 100% sure how this was going to go. So he starts out saying that FSU's contention that the ACC failed to plead that it had taken all necessary steps prior to bringing suit again is without merit. He goes on to say that the court observes that both parties appear to conflate standing related arguments with arguments related to if the ACC's actions were authorized by the ACC. So he's separating the whole standing piece from whether or not they were authorized by the bylaws. And he's going to go into this deeper. To establish standing, so he first talks about how do you establish standing in North Carolina. He'll get to the authorization piece in a minute. But to establish standing in North Carolina, a plaintiff must show a legal injury that's traceable to a defendant's actions, and that the injury can be reduced by a favorable decision. The NC Supreme Court has ruled in a Wilmore versus Charlotte case that there is no law on standing that requires a plaintiff to prove its compliance with bylaws or internal rules in order to bring suit. He concludes that the ACC had standing under this definition and goes on to say that due to the language in the grant of rights, the ACC demonstrated that they have a legally protected interest that has been invaded by FSU's pursuit of a declaratory judgment on the validity and enforceability of the grant of rights. This now meets that three-pronged test that he started out with. There's a legal injury, it's traceable to a defendant, FSU here, and a favorable decision can reduce the injury. So you have to meet all three of them. He's saying by FSU bringing forth this declaratory action, they have done that in North Carolina. After this decision, Bledsoe goes on to say that the parties' remaining arguments, again, are not about standing, but if the ACC was authorized to do this. So this is where we get into that retroactive approval, ratification.
Yeah, yep.
A large part of FSU's argument is that the ACC did not obtain the 2/3 vote prior to initiating material litigation. The court concludes that the FSU's motion to dismiss of a condition precedent, meaning a prior vote, must be denied due to the evidence of ratification, which is unrefuted and dispositive. He notes that the Court of Appeals definition, which is far from turning the law of internal governance on its head, as FSU contends, ratification is a practice that is frequently employed by business entities. I think that's where you were from the very beginning. 4 cases that FSU then relied upon in opposition do not compel a different result, according to the judge. The affidavits supplied by Hostetter and Phillips support the ratification argument. The record clearly demonstrates that the ACC was properly authorized to bring this litigation. So I was always taking it of materiality comes first. He has to rule whether or not it's material. If it was material, then he's going to have to figure out if ratification matters. And he's like, I don't really care about materiality because the ratification makes that mute. And yes, they're allowed to ratify. So you were spot on to this from the very beginning, Steve. What do you say?
Yeah, well, we had kind of 2 questions here. One, first of all, does the court really want to even get involved in the internal procedures, bylaws, and all of that? We weren't sure on that, and he's kind of saying in his ruling like that. The law says we really shouldn't be doing that,
right?
But even if we are going to look at that, they went ahead and they remedied it. They went ahead and ratified it, which is a common practice in business organizations. And so I think from the beginning this was pretty cut and dry, except for, again, the questions he asked during the hearing. And that's one thing, we talked about this in the episode of the hearing, and I'm a little guilty of it myself. You can't look too much into the faces that the judge makes, or a sigh, or a laugh, or sometimes even the questions.
Yeah.
You can't say, oh, he's asking these questions, that means he's going to rule the way I like. I like his question, so he's going to rule the way I like it. He asked some interesting questions, and he found out what he needed to know. And this kind of made sense from the beginning. If you're saying, hey, you didn't do this, well, okay, now we fixed it. Let's move on. I don't think there's a lot of surprises here,
right?
Overall, from the initial filing to where his ruling ended up.
And I think his questioning was probably trying to, now that we have the hindsight of seeing his ruling, was trying to get them to talk about standing, not authorization, right? Because that's what he came out. He's like, both of you, it wasn't one or the other, both of you focused on authorization of this. It's not about that. It's about standing. And you met the 3 requirements, as he talked about, for the standing piece. Done deal. But since both of you were so daggone adamant about the authorization, he went on to actually answer that question too. But he probably wouldn't have had to have done that, although they both were making those, one side versus the other, those complaints, or what they were saying there. It wasn't about authorization. It was about whether or not they have standing.
Both sides put a lot of eggs in that basket. Yes. I think fans at home, whether you're an FSU fan or ACC fan, also put a lot of eggs in that. There was a big debate on did they authorize it or not, when really in reality he's basically saying, North Carolina law says I really shouldn't care too much about how they follow their internal procedures, and even if I did, it's pretty clear that they took steps to ratify it. So again, not a big surprise here, I don't think.
So sovereign immunity, the third biggest item. So in 2022, and he talked about this, like we've had recent case law in North Carolina to address this issue. And I believe I was going back and forth on an MC Supreme Court versus U.S. Supreme Court. He actually talks about both. There were 2 different cases. One was in North Carolina. One was in the U.S. So I made sure I wrote them down correctly here.
Gotcha.
So in 2022, the North Carolina Supreme Court better defined a U.S. Supreme Court's ruling in the Hyatt case. The Farmer versus Troy case in North Carolina better define the answer of consent regarding this case. So the Hyatt case was a U.S. Supreme Court case. After that, the NC Supreme Court heard this Farmer versus Troy, which we talked about a ton. I mean, we knew this was a big deal from both sides. One side said, 100%, this is it. This is what we follow. Of course, FSU said, no, it's not it because, and here's the reasons why it doesn't make sense. You're going to hear that the judge says, yeah, it makes sense, and here's why. But Judge Bledsoe states that the Farmer versus Troy case, controls and establishes that FSU has expressly consented to suit in courts in the state of North Carolina. Why do you say? He tells you why, Steve. He says that FSU's focus on the North Carolina Nonprofit Corporation Act that would require it to be registered in North Carolina and then be issued a certification of authority is misplaced. He gets into then deep discussion on this point, which I'm not going to get into in deep detail here, but he concludes that FSU's conference related activities, so their related activities within the conference with the ACC are commercial in nature, and because of that, they are subject to the sue and be sued clause when they chose to be a member of the North Carolina Unincorporated Nonprofit Associations, which is what the ACC is, and because of engaging in extensive commercial activity in North Carolina. FSU has explicitly waived its sovereign immunity in this state per the Farmer decision. So the judge is saying, yes, ACC, you brought the correct one. You made the correct reasoning and rationale why this makes sense. And he's basically saying, you're correct. It makes sense, and they absolutely can sue and be sued. Lastly, I found this interesting. He did here, and you're going to see it more with the motion to stay, he kind of slaps the FSU's attorney's hands a little bit here. So, and here was one part where he did it. Lastly, he questions FSU's narrow reading of the phrase, all courts, that is in the Florida statute. We've talked about that several times. FSU argued that this all courts only means all courts in the state of Florida when ACC is like, what are you talking about? If they wanted it to be all courts in the state of Florida, they would have said all courts in the state of Florida, and they did not do that. And he completely agrees. He says the Farmer case still takes precedence as FSU has engaged in commercial activities, and he questions, again, why did you even bring that? It's clear what it says or what it doesn't say. So he, again, didn't have to raise this, but he did put that into his opinion here.
Yeah, so this is the first area where I think there's a major door open to having a different decision in the state of Florida. The first couple areas, the ripeness, the standing, I could see that, it seemed to be more cut and dry, and a Florida judge could end up ruling the exact same way on that. This one, I really think that there's a major opportunity here if Florida State can keep the case going in the state of Florida, which, as far as I know, we're still scheduled to have the hearing on April 9th. Where, I could definitely see where a Florida judge would interpret the Florida state laws a little differently. So I have a couple reasons for that. One, even though the case, the Farmer versus Troy case, is it's a North Carolina Supreme Court that is, as they're saying, that it's clarifying a U.S. Supreme Court case. It's still an opinion that was issued in the state of North Carolina, basically saying, well, how the U.S. Supreme Court pertains to North Carolina state law and business conducted in the state of North Carolina. And a Florida judge may look at it totally different. And as far as the reading, and I've read some about this, where how the wording of the law is all courts. And I've seen quite a few people argue and cite many different Florida laws where it says all courts, and other cases where the reason why they write all courts is because in the state of Florida, they don't have the ability, the capability to make laws that supersede federal laws or that should be applied in other states because they are the state of Florida. So I've seen some things about that. So I'm really interested to see the in Florida, how the judge there rules on this. Because if he looks at it the same exact way,
right,
done deal, this thing's going to happen in North Carolina.
For sure.
But if he has a total different opinion, that's where it opens the door where we may see the dueling court cases, which we talked about, the possibility. We'll see. But this is the first one where I think that there can be a diversion. Those first two areas seem pretty cut and dry. I have a hard time seeing a Florida State judge rule differently on as far as ripeness and standing.
Well, standing was about standing in North Carolina.
Well, yes, yeah.
So
okay.
the Florida judge isn't going to. I mean, what's he going to say about
right?
that?
But as far as like the injury, proving that there's a possibility of an injury and how it could be reduced.
Understood.
But as far as the sovereign immunity piece of standing,
for sure,
this is the first area where I think that we could see a divergence.
But it was also my understanding. You mentioned the all courts verbiage. It's also my understanding there's other areas in statute in Florida where they do say all courts in the state of Florida when they really want it to mean all courts in the state of Florida. But you're exactly right. I mean, in terms of crossover here, this was all about whether or not this judge is going to allow this to go first in North Carolina. Right. The answer is yes. We know the answer is yes. Yep. But the crossover with the Florida case is this sovereign immunity piece and the opinions of judges on these types of things.
Absolutely.
So, great point.
And if the judge in Florida, like I said, I know I'm repeating myself, but it's very important. If the judge in Florida has the same opinion, this thing is going to be just staying in North Carolina. So it's a huge inflection point in the case, I think.
Both sides, yep. So by page 42 now, we get into every motion one by one. I'm not going to go over them in great detail, but I think it's important that we do go over all of them. So the first one here, in terms of his conclusion, so the first one here, FSU argues that the ACC did not name the actual party to the grant of rights, FSU instead of the FSU board. We talked about that, I think, once. I laughed at it. I'm like, that's crazy. The judge says this argument is a non-starter. Done. Number 2, breach of the grant of rights. At this stage, the court concluded that the ACC showed that the FSU board approved the execution of the grant of rights and its subsequent amendments. The court also concludes that the FSU board should be stopped from challenging the grant of rights. Number 3, declaratory judgments. The court concludes that the ACC's declaratory claims can proceed. Number 4, breach of obligation to protect confidential information. The court concludes that the ACC has pleaded to the confidentiality of the ESPN agreements as well as FSU's breach. So 4 for 4 here for the ACC. Now number 5, the sole win for FSU in terms of a dismissal, this being the breach of fiduciary duties owed by FSU to the ACC. The judge states the uniform, I didn't write it all down. I think it's the unincorporated nonprofit association laws or statutes, which help the ACC regarding their sovereign immunity piece. We talked about that. It doesn't help them here because that actually states that a nonprofit association is a separate entity from its members and are not co-principals. Also, the ACC cannot establish the existence of a de jure fiduciary relationship with FSU under a joint venture theory, which is something they were trying to do. The court granted the FSU motion to dismiss as the ACC's 5th claim of relief of breach of financial fiduciary responsibility with prejudice. So again, the lone win there for FSU. The last one here, the 6th, breach of implied duty or good faith and fair dealing under the ACC bylaws. The judge points out that the NC law, North Carolina law, has long recognized that contracting parties not do anything which injures the rights of the other to receive the benefits of the agreement. He concludes that the allegations are sufficient to claim this breach and the FSU request is denied. So there are the actual 6 different conclusions that he gave for what was being asked for. What are you thinking there, Steve, specifically the fiduciary responsibility piece?
So, well, I'm going to say about all 6, it's important for people who are following, fans, to understand these. He was making rulings on whether to dismiss these or not.
Yes, right.
Whether they can be heard, basically. He's not making a ruling on the merits of the actual case in these different areas. It's just whether or not can they be heard in North Carolina. So that's something really important. I'll tell you, none of these 5 out of 6 didn't surprise me very much.
Okay.
Especially if once you get past the for me, sovereign immunity piece was bigger for me. We also talked about the as far as having standing, the ratification piece. So a lot of those weren't big surprises to me, especially in North Carolina with the cases that they have cited.
Right.
I was a little surprised with number 5.
Okay.
That they went ahead and dismissed that part, and so they're not allowing the ACC to make the argument that Florida State breached any fiduciary responsibility. And to me, that takes a lot of risk out of away from Florida State. That eliminates quite a bit of risk. They don't even have to deal with that part in the case, which could have caused them to actually have to pay potentially more money than whatever agreement that's going to come out or whatever they were going to owe under the grant of rights. So I think it reduces their risk, and there's a lot of speculation that some of the other schools, Clemson, who's filed a suit, University of North Carolina, which maybe some of their Board of Trustees members are looking at possibly joining this suit or having their own suit. That number 5 item was an indicator to them that, okay, maybe there's not as much risk in this as possible, as we thought there could be. So anyways, all 6 of those, I wouldn't say a huge surprise in any of them. In North Carolina. We thought the sovereign immunity, I thought from the beginning that might have been an issue where the judge would want to push it, punt it, get it out of his court. But I think it was clear from the hearings, and especially the judge that this went to, in the business court of North Carolina. He's very experienced in these cases. And where he talked about the other cases that were cited, which were also in his court and had gone up to the appellate court and been ratified, and gone up to the Supreme Court of his state and been ratified. So I think he was very confident in making these rulings and continuing on with this case. So a lot of them not very surprising, but the one that was dismissed, I actually was surprised. I thought if he kept this in the state of North Carolina, that would stay as well, and Florida State would have some risk on top of what monies they might already owe via the grant of rights. So I think that's a big indicator to the other schools as far as their decision. Do they want to file suit as well?
So fiduciary duty is off the table, but still breach of contract is on the table. Breach of protected confidential information, not maintaining that confidentiality. Breach of good faith and fair dealing. So again, a lot of things still on the table, but yes, one thing off. We then get into the motion to stay. And he had a lot here. Again, I'm going to keep this fairly short, but the essential question for the court here is, from what the judge says, is whether allowing the matter to continue in North Carolina would work a substantial injustice on the moving party. That is what needs to be determined. Is there a substantial injustice? He states that after careful consideration and review, the court concludes that having this continue in North Carolina would not work a substantial justice for FSU, and he denied the motion to stay. He goes on to state the ACC's choice of forum is entitled to deference as the party first to file. Also, FSU's arguments hinge on an erroneous view that it is the natural plaintiff in this dispute. And he talked about that in the hearing. He was really talking about who is the actual plaintiff. I mean, that was one of the discussion points in the hearing. The non-breaching party, the ACC, is the injured party in the dispute. Thus, they are the natural plaintiff. The ACC did not engage in improper conduct or procedural fencing by this filing in North Carolina. Further, the applicable law strongly favors allowing this action to proceed in North Carolina, as the key contracts are governed by North Carolina law. Lastly, FSU claims in the Florida action, he brought up the Florida action several times, he's doing it here, action for anticipated defenses and anticipated counterclaims may be governed by Florida law. the core issue in the two actions, which is the enforceability of the grant of rights, favors resolution in a North Carolina court. So he's kind of, to me, he was answering some questions that maybe weren't even really before him yet, but he was looking ahead. He looked at the Florida action, and is basically, he's very, very strong in his wording here that these contracts are North Carolina contracts and they should be heard in North Carolina. I'm pretty sure I know what you're going to say about Florida, but what do you think here, Steve?
So first of all, I think after when you're reading this, after you read the motions to dismiss, all of these make perfect sense because he's already made rulings on these. He's saying that sovereign immunity doesn't apply based on this North Carolina case. He's already laid all of this out in the motions to dismiss. So no surprises here in the motion to stay, I don't think. When you look at his rulings on the motions to dismiss. So some of the wording here, what I'm thinking, what I'm wondering, okay, and I've seen a little bit of speculation. So let's say the Florida judge rules differently than him, especially as far as the sovereign immunity piece.
Yeah.
And the Florida judge says, no, we're going to go ahead and either hear this first or hear it concurrently, or we're just going to ignore your case over here and go along, which from what I understand is a possibility.
Okay.
In that case, I've seen speculation where one party or the other may go to the U.S. Supreme or to a federal court, which could eventually go to the Supreme Court, and basically argue, hey, this case should be here, or it should be a federal case, not in the other state. So, I think he's basic. To me, some of what he's saying there, he's talking to the parties, to Florida State and the ACC, but he could also be talking to an appeals court in his state, or to the court in Florida, or possibly to a federal court that may want to come in and intervene.
Or to the other members of the ACC.
That could be as well.
His opinion is, and if you remember, and I know you do, but if our viewers remember, he was also given the Clemson case.
Yeah.
So he is putting forth his opinion that this grant of rights, the actions against the enforceability of the grant of rights, in his opinion, you know what he's going to say with the Clemson case.
Yeah.
This is North Carolina court. A resolution has to be done in North Carolina court. So, I agree with you on the motion to stay. The first half of what I said, obviously, if he's not going to dismiss it, he kind of laid out things, and he went over that in his mind substantial injustice wasn't going to happen. Yeah. I was surprised he went on then to kind of go into that and delve into, hey, I'm letting you know, and whoever that you is, you mentioned 4 or 5, the other schools, whoever that is, I'm letting you know this is how I'm going to rule. This is my opinion on these contracts.
And what I'll say is, you make a good point. He's letting someone know, but I think he's also saying the why.
Sure.
He's not just saying the what, he's saying the why.
He is, yes.
And I think that to me, that is he's telegraphing it to the courts in the other state.
Good point.
An appeals court, or potentially a federal court.
Which is, again, why, it's so important to the ACC to get this. I mean, this is important. He's out in first in this. He's giving his view on this. And that doesn't mean a Florida judge can completely disagree and even turn a blind eye and do whatever he wants. He absolutely could, or she absolutely could. I can't remember if it's a male or female down there. But, and this is why the venue jurisdiction stuff we talked about was so important. Got some answers on it here, but what you got?
Well, in the very first video, we said it was a huge coup by the ACC to file first. And I'm not saying they engaged in any shenanigans. They got to the courthouse first, whatever. And the judge has already said, they did it. They were the natural plaintiff in his mind. So it was a huge win we said it was a very good strategic move for them to get in first, get this filed first. And if they kept it in North Carolina, which it's at least it's going to go on in North Carolina. Whether it also goes on in another state, we'll see. But it's going to move forward in North Carolina, and they're a little bit ahead so far. That's a huge win for the ACC. And so we said that would be a huge win, and it is. This was a huge win for the ACC. They wanted the North Carolina courts. It was a strategic move for them. Being in this court, the business court, with this judge, and with the precedents that have been set in North Carolina, again, just a huge win for them. Great strategy by them. And obviously these laws and the case laws that have been submitted and the decision by this judge, who is very cognizant of the other decisions that have been made in his court by his colleagues, as he's mentioned, and by the appellate court in North Carolina and by the North Carolina Supreme Court, this sets up beautifully for the ACC.
Well, and I got to say, the ACC made, according to this judge, the better arguments. I mean, what he found here, especially with the ripeness piece in the sovereign, I mean, he took it almost verbatim out of what they were saying. The Troy case, the ripeness stuff, they both kind of missed. They swung and missed on the actual definition of standing. And I think that's probably why he was asking some of those questions, was to try to get him there. I want to go back and kind of listen to that again now to see if that's where he was trying to head with that. But yeah, I mean, I'm not trying to be an ACC homer. I know I got called out the last time. I'm just reading it as I see it. But two of these three are almost out of the ACC playbook here.
Well, and now here's the thing is, so we talked about this. The ACC lawyer knows this judge. He's been in this court for a long time.
Yep.
He knows what this judge is looking for. I mean, their attorney, the ACC's attorney, knows how this judge likes documents to be filed.
Absolutely.
So that doesn't surprise me at all. And yes, this judge, he loved the arguments they made, and again, they knew the court, they knew the laws in North Carolina, the case precedent, and so the arguments they made make a lot of sense in the state of North Carolina in this judge. We'll see what a Florida state judge thinks about these, and that judge may swat their arguments away and say this is absolutely ridiculous. So we'll see how that goes.
Complete 100%, complete 180 down in Florida. We get that here on the 9th. I know we're going to drop this one Monday, and that will be on Tuesday. So. We're going to stay on the hearings here. We're not going to go tit for tat on filings necessarily unless there's something really, really important that comes up. But exciting stuff. Thank you guys for watching. We will stay on this. We're going to do a separate episode on the motion to seal. We'll get that out later in the week. Definitely a lot shorter than what this one was. This was the beefy one. But again, hey, like this one. Subscribe if you like our content. We'll see you next time on the Big Mountain.
The ACC is out of the gate with a big 1-0 lead.